U.S. Supreme Court set to hold historic hearings on President Obama's signature legislative achievement. Top Democrats say the law is constitutionally, quote, ironclad. Some critics beg to differ. Let's bring in our legal panel. David Schwartz, defense attorney, former prosecutor; Rachel Self, a trial attorney. Good to see you both. Rachel, let me start with you. Day one, which is Monday. The question is the case premature? Because there's an old 67 law passed by Congress that said federal courts may not rule on tax laws until they kick in. Well, here, the tax isn't due till 2015. So isn't this premature?
No, Greg, it's not. And the reason is because it's not a tax. What it is it's a penalty that's being collected during tax time. So even the Supreme Court has ruled that it's appropriate to hear it now.
Well, President Obama and the Democrats insisted it was not a tax, but they now say it is.
Well, I mean, there are certainly a tax implication here. You know, if someone does not get health insurance, there will be a tax. So, but I agree with Rachel, though, that this is not a tax itself. It's a fee, and therefore it's mature for the Supreme Court to hear the case.
You know, Rachel, it's interesting that both sides say the Anti-Injunction Act of 1867 doesn't apply. The Supreme Court wants to hear it. I have a theory on this. Supreme Court doesn't want some pinheaded law professor, 20 years from now to write a law review article that says, oh, they never had jurisdiction over the case to begin with. So I think that's why they're doing it. I suspect that they're going to dismiss it immediately on day one, which brings us to day two, the individual mandate. There are two arguments. We'll put it up on the screen. Here's the pro argument. The government claims that the cost of uninsured substantially impacts commerce to the tune of $43 per year. The con argument is that Congress is forcing people to engage in commerce. They're not regulating existing commerce. Rachel, which is the best?
Well, I think that Congress definitely has the right to regulate commerce in this particular instance. And just because an individual chooses not to have health insurance coverage doesn't mean that they're choosing to not participate in the economic transaction. And what they are choosing to do is then make everyone else pay for their poor decision to not have coverage. I think that this is definitely constitutional under the Commerce Clause, and there's an old case, Wickard v. Filburn, which makes very clear it was a guy who was a wheat farmer who during the Great Depression was manufacturing too much wheat for what the government had already regulated was enough, and it was for personal use. And what the Supreme Court ruled back then was that participation was in itself an aggregate effect economically.
You know what, David? She makes a great point, and it is a seminal case, including the Raich case. But the difference is, back in the wheat farmers and the marijuana case and the Raich case, I mean, they were engaging in active participation of doing something. But here, what you're really doing is making people buy something simply because they exist, simply because they breathe air.
Right. Certainly, you're forcing people to buy this insurance where maybe they normally wouldn't. So you're forcing them to engage in interstate commerce. However, I do think the stronger argument will be that the Congress has broad discretion to regulate interstate commerce. And certainly there is an interstate commerce argument here. The buying of insurance does affect that. And I believe the conservative Supreme Court, even today, will allow Congress to act, and they will not get involved with that.
All right, then we get to day three.
I agree.
Severability. Yeah, you guys are both on the same page. Severability. Day three. If the mandate is struck down, how about the other provisions? Rachel, what do you think?
Provisions will go out right with it because they made this an all or nothing law when they put it together. So they said if you're not going to accept this aspect of it, then you can't take it in pieces.
Yeah. What do you think, David?
Well, I think the question becomes, is it really intertwined with the other parts of the law? And I think there's a good argument to be made that it's not intertwined with the other parts of the law, and you can sever this out. And even if it is struck down, the rest of the health care law will go on.
All right, the sleeper argument, I think, is actually the very last argument the Supreme Court will consider: sovereignty. Does the law's expansion of Medicaid violate the sovereignty of states under the 10th Amendment, forcing them to spend their own money. Since when, Rachel, does the federal government have the ability to force states to do such things?
Well, here's the thing, okay? What it boils down to is people are already forcing other people, taxpayers, to cover the insurance, because when somebody walks into the emergency room, a doctor has to treat them if they need the care. And so in this particular instance, what they're trying to do is prevent it from becoming an emergent care situation and make it something so that at least it's covered, as opposed to making it the most expensive treatment available.
All right, prologue, David, I want to put this one to you. Kennedy, Roberts, Alito, and Scalia have all, if you examine their past decisions on interstate commerce, they have all given Congress broad power, regulatory power under the Commerce Clause. So, boy, if you had to make a guess here, is your guess that the conservatives will not automatically reject this law?
Oh, absolutely not. As a matter of fact, this is a very conservative law, if you think about it, because the conservatives on the Supreme Court, the traditional conservatives anyway, won't get into this fight between the executive branch of government and the legislative branch of government. Right. They're going to let them fight it out. So certainly I believe Roberts will vote for it, and I believe Kennedy will vote for it, and you'll have a 6-3 upholding of this law.
Rachel, it is likely the 4 liberal justices, Sotomayor, Kagan, Ginsburg, and Breyer, will uphold the law. Let's put up their pictures on the screen. But let's assume, for the sake of argument, that the 4 most conservatives, Thomas, Scalia, Roberts, and Alito, vote to overturn the law. That leaves Kennedy as the swing vote, right? You following me? George Washington University law professor Orrin Kerr, who used to clerk for Anthony Kennedy, says that he has studied all of Kennedy's past decisions on this, and he says he is absolutely convinced that Kennedy will uphold the law. What do you think?
I agree. I think that the law is constitutional. I think that the Commerce Clause is a great way to regulate this particular issue. I think that it's perfectly feasible to allow it to happen, and I think that the Supreme Court's going to allow this to continue.
All right. And what's next? Broccoli? Health, you know, we got to go down to the health gym and work out.
It's not like that. It's
they don't
really
have to
not.
Agree with the law.
Really
they
not.
just have to vote to uphold it.
I really hate broccoli. Okay, David Schwartz, Rachel Self, good to see you. Do you like broccoli? You don't like broccoli?
Thank you.
I love broccoli, and broccoli's good for you.
Yeah, you can listen to